live, joined today by Seb Burrows. Do you want to say hi, Seb?
Hi, I'm Seb Burrows, Managing Partner at the firm with Liza. Very, very pleased and excited to be here.
Yeah, and live again, and hopefully no dogs interrupting this time for anybody that was around on the last occasion. No barking, they're all locked away. Shall we just kick off then, Seb? Shall we just start from the top? We've had a load of questions that have come in on email, so thank you to everybody that has sent in questions beforehand. And what we will do is try and run through as many of these as we can. Also, there is, I believe, a chat function. So if you have any questions whilst we're live that you would like answered, please do pop them in the chat and we will run through the chat as well. Do our best to answer as many of these as we can. Any that we can't answer today, we will try our best to follow up with afterwards. I'm going to start then by asking you a couple of questions on divorce, Seb.
Put me on the spot.
So one of the questions that we've had in is, how much does a divorce cost where there are no assets and no dependent children?
It's a really good one, isn't it? And I think one that we get asked quite a lot because obviously costs are a massive consideration for people. There's a court fee for getting divorced around the £600 mark, and that's payable whether people are incredibly rich or not. There are some exemptions, but they're very small. But generally speaking, that's the lowest the cost could possibly be. But when talking about the financial side of things, when there are no assets and when there are no dependent children to think about providing for, things are simplified. Many people can organise their divorce themselves online and sort that out, and many don't address the financial side of their divorce. That in itself can leave problems open for the future, so we'd advise against that. Always really, really sensible to talk to a solicitor about the situation. So where there are no assets, where there are no dependent children to think about providing for, I think it can be quite tempting for people to think, oh, well, I don't need to sort anything out. I'm going to leave that alone. It won't affect me. There are potentially some risks there. So always really sensible to get some legal advice. And we'd be very happy to speak to people about that if they're in that situation. But in answer to the question, it could cost much less than it might do otherwise.
Okay.
I think that covers it, Lisa, doesn't it?
Yeah, no, absolutely. Sticking with divorce then, another question that we've had is where to start in the divorce process after a long period of separation. What's the first thing they need to think about?
I think communication is probably the most important one. I think the greatest pitfalls that I encounter, and I know that you and I and lots of our colleagues encounter, stem from things coming out of the blue for someone on the receiving end of a divorce. If communication has been really, really hard, or in situations where there's been domestic abuse where, communication really isn't something that people want at all, we can help. It doesn't have to be an attack ever. Being open, being frank, being straight with people, treating people humanely, that I think is the best place to start. Getting legal advice, getting yourselves sorted, getting everything clear in your mind, knowing the path ahead and preparing calmly for it. I think that really is the best place to start.
Absolutely agree.
I'm going to come to you with some questions.
Go on then, hit me up.
Talk to us a bit about mediation and what it's useful for. I find that some people know about mediation, understand what it's for. Others think that mediation is marriage guidance, and other people have no idea about it at all. What can it help with, and what can you tell us about cost?
Yeah, I think there's a common misconception that mediation is about getting you back together, and it's absolutely not. But the purpose of mediation is for you both to sit down with an independent third party and talk through the issues that you can't agree on. So those can be children issues, they can be financial issues, although those should be dealt with separately and not in the same session. And it's about having somebody there that's impartial, because if you're going through a separation, you can't agree on things. If you're trying to have conversations together, sometimes you might find that they go off on tangents, or things are being considered that probably shouldn't be. And so the purpose of the mediator is really to make sure conversation stays on track, make sure that you are trying to meet the objectives that you've come in with, and really to help you unpick the difficulties that you've got and to be able to reach an agreement. Now, mediation is brilliant. It can be done in person, so you can do it face-to-face in the same room with the mediator. It can be done online. It can be done with you in the same room as the mediator. It can be done with you in separate rooms with the mediator going in between, so that's called shuttle mediation. And it can also be done with solicitors present as well. So, where you would be with your solicitor, your ex-partner would be with their solicitor, and again, the mediator would go between the rooms. The benefits of mediation are definitely the cost savings. So if you are able to go to mediation and reach a settlement, it probably takes on average 2 or 3 mediation sessions together, and parties are either very clearly able to agree or not agree after that. But if you are able to agree, what you've effectively done is reduce the cost of the negotiating, because it's dealt with in these fixed sessions rather than a number of months sometimes of solicitors' correspondence going backwards and forwards. It also means that you're dealing with things directly, so it's more time effective than letters. If you think a letter goes from one solicitor to the other solicitor, it needs to be sent from that solicitor to the client and then back again. That in itself just takes time. So mediation is much quicker to get these things resolved. And the idea then is that if you reach an agreement at mediation, you would take that to a solicitor and they would be able to draft that into an agreement or an order if that's appropriate. So lots of benefits to mediation. It's definitely something that should be considered. It is not right for all cases.
Yeah.
So particularly cases where there are severe allegations of domestic abuse, for example, it may well be that the mediator at the initial intake session decides that actually mediation isn't appropriate, but it should definitely be considered.
I think psychologically it can be really beneficial because both people, if they want to make it work, are committed to it. They know that they can't go to 1,000 mediation sessions. That would be ridiculous. So they're committed to resolving things quite time efficiently as well, I think. And yeah, it can work really, really well.
Mm-hmm.
There's another question here that's good. A final order, so final order of divorce, has been granted, so the marriage is dissolved, but a financial application is being attempted. Is there potential to get a settlement and get the party's name on the house deeds when the ex is refusing? So I suppose this is a question about the divorce has happened, but the negotiations and the finances are still ongoing.
Get their name on the house deed.
Well, I wonder whether it's get their names
off the house deeds, maybe. Yeah, I mean, if they can't agree what happens to the house, and perhaps you've tried mediation, you've tried solicitors' letters, then ultimately you would be looking at an application to court for the court to make an order, or an arbitrator for an order to be made that the house is either transferred or sold. So the courts could deal with that within financial proceedings.
Yeah, I completely agree.
As we're dealing with divorce, should we drop down to sort of finances? It seems like that flows.
I think that's a bit more natural, isn't it? Yeah, very happy to do that.
So let's look at the family home then.
We've got a few good questions there.
There's quite a few questions that have come in relation to the family home. So the first one is that you've got property owned prior to the marriage in one person's sole name. The property was remortgaged and rented out to provide funds for the marital home, but remains in the person's sole name. Is the spouse entitled to a percentage, and how much? This is quite on topic at the moment, whether pre-marital assets should be ring-fenced effectively. What are your thoughts, Seb?
I think this is really on topic. And there was a recent case that loads of people and loads of our clients, new and existing, have encountered in the press, a case called Standish. That deals with exactly this. But Standish is really important at reinforcing things. It's not a groundbreaking change in the law and how we approach things. And weird as it may sound, the legal lingo here talks about mingling. And so we often encounter cases where there's a question mark over whether a property falls in the marriage or out of the marriage and can therefore be excluded. And the extent to which it's mingled and blended in and relied on is really, really significant. So in this situation, one person in the marriage has the property in their sole name, but it was remortgaged and rented out, and the rental income was used by the family. And to that extent, I think really is likely to be considered mingled. If it was treated like an asset that was generating an income in this marriage and providing for people's needs, that is really going to severely limit the person in whose name the property is, limit their ability to say that it should be excluded. So in answer to that question, is the spouse entitled to a percentage and how much? Well, yes, they're entitled to argue that they should share in it. The extent to which they can share and therefore what percentage comes down to fairness and equality and how much is needed. What else is there in this marriage? How is this couple going to be provided for their housing and the children and so on? So it's all part of a much bigger picture. But ring fencing stuff out, or ring fencing assets out of a divorce, is a really delicate field and one that really requires really careful analysis of everything.
Yeah, we've had quite a few questions come in relation to being able to ring fence assets that were sort of pre-marital or post-separation. And I think the big issue is that for the, when we're looking at cases like Standage, we're talking about multi-million pound cases.
Yeah.
For the average person, the reality is that, we're taking one house and trying to make 2 new households from it. And that means that there often isn't enough money to go around to be able to run these arguments successfully, because the courts will say, well, actually, you both need to be rehoused. We both need to meet certain basic needs. And once we've done that, there isn't any additional funds there. So you do tend to be able to successfully run these types of arguments. There does tend to have to be a significant number of assets to be able to be successful with them.
Yeah.
And they are tricky. And, we have to look at the source of those assets, where they came from, how much they've been mingled. Definitely not a quick one to answer, unfortunately.
It ties brilliantly to the next question, and the answer is very similar, isn't it? The question is a property owned before the marriage by one party still considered a matrimonial asset? For fear of wanting to sound like Vicky Pollard, you're a but no but.
Yeah, it depends, doesn't it? I mean, first of all, it depends what the property is. So if, for example, the property was the family home, so if one party had brought a property into the marriage and that property had become the family home, whether or not it was still in their sole name during the marriage, you will really struggle to convince a court that should be separate. If you're talking about a second or third property that was owned by one party, then it comes back to the previous question as to how much it's mingled. It comes back to what the needs are of both parties and whether those needs can be met if we exclude that property from the calculation.
Yeah.
I'm going to call the next one my EastEnders question, because I find on EastEnders, not that I've watched it recently, there's always, through a separation, somebody's being kicked out, locks are being changed. It's all very dramatic. And so the question is, are you permitted to change the locks on the family home if somebody has moved out? And I think the reality of the situation and what we see on TV can often be two different things. So do you want to enlighten us, Seb?
I think we were going to fight over this question and who would get to answer it. I think, you're right. It is. And one that so often happens. I think there's a huge, not a conflict, there's a rub up between what is practically possible, what ought to be done, and legally what's right. If a home is the family home, whether it is in joint names or a sole name, it's a family home, and both people are entitled to treat it as home. And so it would be wrong and unlawful to exclude the other person from it. But of course, in practical terms, if one has left or been perhaps, arrested and removed and bailed not to go back, of course it's possible for the locks to be changed. They can be changed. But in a situation where someone a marriage has really broken down and it's been really difficult, and one has said, right, I'm just going to get out for everyone's well-being. There may be no fear involved. There may be no threats involved. There may be no real problem with the person that's left going back. But the other person remaining might decide they want to change the locks. Well, that person visiting their house and finding that the locks have been changed is, in theory, perfectly entitled to break a little pane of window, reach in and let themselves into their own house. But of course, that then gives rise to loads of issues that we find we encounter quite often to do with intimidation and harassment and so on. And so the question over whether the locks should be changed is often a symptom of a bigger consideration, and one that we tackle regularly. In a situation where people have separated and there is a jointly owned house, the best approach that we find is, again, for communication to be key, to say, well, look, I'm moving out, I'm renting this flat for 6 months, or I'm staying with my brother Pete. But it is still my house. I still have my stuff there. I do want to come round and see the children and do bath time. But this is when I'm going to come round. This is what I would like to do. And I'm going to give you notice of when I'm going to come round. I'll send you a text 24 hours before. That kind of stuff really helps. And it's about diffusing problems before they happen, rather than inflaming a situation by changing the locks out of the blue and surprising people or refusing access and so on.
Yeah.
Pandora's box sometimes.
Yeah, it's about giving peaceful enjoyment as well. I think there has to be an understanding that if you've left the property and you're living somewhere else, then the other person is entitled to peaceful enjoyment. It's not fair if you're kind of rocking up unannounced and not giving any notice, because you put that person on edge, that they're not able to relax in their own home effectively. Yeah. So it is a tricky one.
It ties to another question that we haven't been asked. Does leaving the house mean that I'm entitled to less? I often get that. No.
Yeah, that seems to be a common misconception. If I leave the property, does that mean yes, that's it. I'm kind of foregoing my claims, my financial claims against that property. And yeah, very simply, absolutely not. You know, your financial claims remain the same whether or not you're living there. Which one do you want to go to first? Do you want to pick one?
I think there's a really interesting one here that we both like the look of when we first saw it. Is there any relevance in a financial settlement if the family home has been adapted for physical disabilities?
Yeah.
We do encounter this, don't we? Not very often, but we do.
Yeah. I had a case not long ago, actually, where the property had been significantly adapted due to one of the children's disabilities. And it's absolutely a factor that needs to be taken into account, because ultimately we need to ensure, when we're looking at needs and housing needs, if we have a party or if we have a child that has a specific need for certain adaptations to the property, if we're saying the family home is going to have to be sold, then we also need to make sure that any replacement property is going to meet those additional needs. And that might mean that we have to factor in additional costs, or we need to look into whether there are any funds that are available elsewhere through councils, etc., to be able to make those adaptations. So it is a really interesting question. I mean, the case that I had as an example, it was a 5-bedroom property, which was being lived in by mum and 2 children, one of which had the disability and the adaptations. And in that case, the property was just too big to justify her continuing to reside there with the children. But we did have to make sure that she had a housing fund that was sufficient enough for her to be able to not only just buy a smaller property, but buy a smaller property and adapt it to meet the child's needs as well. So it's absolutely something that would be taken into account. Equally, in that case, had the property been smaller to begin with and already been adapted, she probably would have had a much better argument for remaining in the property. And perhaps, a court would have been more sympathetic to that as an argument.
I think it's a good example of the picture being as full as possible. How has it been adapted? How important are those adaptations? And like you say, needs are the priority.
Yeah, absolutely.
Ensuring people's needs are met, and of course, children's more than anyone.
Oh, inheritance then. So this is an interesting one. So wife has received property and savings from the death of a parent, but has not declared it in financial disclosure. What can be done?
This is one that arises often enough, isn't it? Okay, going through the divorce process, going through financial negotiations, whether it's outside of court or through the court process, transparency is really important. It's relevant. Inheritance received is important and significant. And again, it comes down to needs. If there is absolutely loads of money in a celebrity divorce and clearly sharing things equally meets everyone's needs, then it may be possible to say, well, look, that inheritance was received right at the end and I'd like to ring fence that out and it's not needed. Then there may be strength in that. But in the normal course of things, in the real world, that inheritance will make a real difference in enabling us to create 2 homes out of one. And the courts do look to it. They like to avoid attacking, is the word that's often used, inheritance if they can, but won't shy away from taking it into account when ensuring that people's housing needs are met. And so it can feel really, really difficult, this one, especially inheritance. But imagine a 25-year marriage where the in-laws have brilliant relationships with their children's spouse, and they may have cared for them, lived very close to them, and parents are old, their deaths and future inheritance would have been something that would have been considered, maybe not openly, but it would have been known about. And to say, oh, well, by its own nature, that should be completely ignored, isn't necessarily fair. It's the specific circumstances that need to be taken into account and putting needs first.
Yeah, I think we have to look at the nuances as well between future inheritance and inheritance that's crystallised at the time that we're looking at the divorce proceedings. So if, and as awful as this sounds, if both parents are still alive, but you're expected inheritance from a will, that's not something the courts will take into account, because people are at liberty to change their will at any point. So that inheritance is by no means guaranteed. If the person has died and the inheritance, whether it's going through probate or has been received from them, then that inheritance is crystallised. So that's money that they actually have access to and will actually absolutely be taken into account. Going back to kind of what can they do if the other party won't disclose the amount of their inheritance? Well, both parties within divorce proceedings have a duty to full and frank financial disclosure. If that isn't provided, you can raise questions. And I think in this type of circumstance, the questions that we would be asking would be to see a copy of the will.
Yep.
We'd be asking to see for correspondence or something from the probate solicitor, or a copy of the IHT, the inheritance tax form that's been submitted. So we would be asking for very specific documents as part of the disclosure process, which would then tell us what the inheritance was effectively.
And if they continue to be evasive and refuse to provide the information, then the biggest option is to say, well, I'm going to make an application to the court, and the court will require you to provide this information. And it's such an obviously gaping hole that I think any judge would reasonably expect someone to provide that kind of information.
And that kind of feeds into a next question, actually, in relation to finances about hiding assets.
Yeah.
So the question was, wife believes her husband has hid savings and taken his name off the business he owned with his father. They've agreed to do financial disclosure. What's the best course of action? I mean, the financial disclosure, I suppose, is the best course of action, isn't it, Seb?
But for it to be really robust as well, and for that communication between client and lawyer to be really open and fluid, and for us to be given as much information that they know about the business so that we can then ask the right questions. And that disclosure process, whether it's through courts or done privately, usually requires information about finances over the course of the last 12 months. But of course, in relation to a business, we can ask to see more, and we can ask all the necessary questions to get the answers out here. If it has been transferred, we can ask them why. The fact that it might have been transferred out doesn't mean that that's it, an opportunity is lost, because we can say, well, of course, that was and is still an asset in a marriage. The fact that names have been changed on documents doesn't change that fundamentally. It might make it more difficult for us to get to it, or create risk that that asset might slip away. But, we can consider protections there. If a house owned solely by someone is at risk of being sold, there are steps that we can take to protect it. In the worst case, freezing injunctions are available. So there are all sorts of tools available to us, but absolute transparency and asking the right questions and really probing so that we've got full information helps us understand what the financial landscape is, so that we can consider what the fairest division of things is.
Yeah, I think definitely looking at getting that financial disclosure, looking at the Form E, then having a look at Companies House to see how the disclosure reflects against Companies House. And then, we have a forensic accountant that we work with here at Stowe. So my next course of action would then be to ask Suzanne to have a look at it for me as well, to give her advice from an accountant's perspective as to if there's any additional questions that we should be asking and digging into. And there's all sorts of arguments. You talked about freezing injunctions. You've also got, we could argue an add back if it's been transferred at an undervalue. Courts can also undo transfers that are an undervalue. But this all costs money because we're talking about court applications. And so what we really want to do is just start with the financial disclosure, take it from there and see if we can reach an agreement.
And very often we know the kind of advice that the other lawyer will be providing to the other spouse. And we can kind of steer that advice by asking the right questions and making the right comments. They will be saying to the husband, the fact that you transferred it out of your name and now it's left just in your father's name doesn't mean that it's gone. We're going to have to provide this information. Again, communication is key. Let me pick another one, Lisa. We've had a question in here that asks, can finances be split 75-25, so 75%, 25%, if the party earns less than their ex and will be the primary carer of children aged 16 and 18?
Okay. It always intrigues me when I have clients that come for initial meetings and immediately start talking about percentages.
Yes.
And it runs from 50-50 to 60-40 to 70-30 to, in this case, 75-25. And I think it's not, the first thing to say is it's just not the right starting points, because what does that mean is more the question. If we split it 75-25, what does that mean? The starting point when we're talking about financial settlements is that all assets, whether in your name, their name or joint names, are put into the matrimonial pot, and that pot will be split equally between you. Yeah. What the courts then have is they have a checklist of things that they take into account. So things like the length of your marriage, your earning capacities, any particular contributions, any children, any disabilities. So quite common sense factors. And what they then say is, right, okay, based on these very individual factors of your marriage, is 50-50 fair? And if not, how should we move away from 50? How far should we move away from 50-50? Now, if we're moving away from 50-50, it's usually to meet a need. And we have three needs. So we have housing needs, We have income needs, so that's where spousal maintenance comes in and where you've got a difference in earnings. And then we have pension needs. So what we would usually do is, rather than start with the percentage and then see what we can do with that, is we would start with what are the needs. So if we can't meet needs from 50-50, we start with the needs, and then at the end we reflect back on the percentage. Because if we meet needs and then it looks like we're doing 90-10, that's never going to get past a judge. So we then have to go back to the drawing board. So it's more about meeting needs rather than notional 75-25s. Now, where the earning capacity will come in, as in this case, so one party earns less than the other, is potentially in two places. First, it might be in relation to maintenance. So is there a degree of spousal maintenance that needs to be paid from one party to the other because the party with less income is unable to meet their income needs and that they have done everything they can to maximise their own income? And the other place that it will come in is in relation to mortgage raising capacities. And this is probably the most common one these days. So it may be that a 50-50 split of the capital assets is unfair because one party earns more and therefore they're able to raise a significantly higher mortgage, which means that if you split the assets 50-50, the party with the higher mortgage raising capacity would be able to go off and buy a much nicer house, and the party actually with the lower income might not be able to raise a mortgage at all. So it doesn't work out fair. Whereas what we would look at is actually how much do they each need to be able to get similar properties, for example. And it might mean that the person with the higher income needs less ready cash because they've got a higher mortgage raising capacity. And so they might end up with slightly less or less than 50% of the overall pot. But the end result is that they both have equal housing. Yeah. And that's how we would reflect back on their percentages. So yes, finances can be split away from 50-50. I think it's quite rare to get up to 75-25. I would say most cases...
That's high, isn't it?
Yeah, I would say most cases are kind of between 60-40 and 50-50. We do have the odd case that goes beyond that, but there really has to be a reason for it. But as I say, it's not really helpful to look at those notional percentages to start with. It's about meeting needs. And then the other part of the question is obviously being the primary carer to children aged 16 and 18. And this is a really, really tricky one because the reality of the situation and what is probably morally right, so the legal answer and what's probably morally right are two completely different things. So morally, we know as a society that 16 and 18-year-olds are not going to be leaving home anytime soon. And, with housing prices and rental prices and all the rest of it, children are often dependent on their parents well into their 20s in a lot of cases. However, what the law says is that once you've reached 18 and you've left your full-time secondary education, you are an adult and therefore you're not factored into things like housing needs. So it's a really, really tricky conversation. And, it's one of those where you really need to be trying to agree something rather than relying on a judge to make a decision because you might not like the answer that you get from the judicial system.
Yeah, I completely agree. Yeah, exactly that. And, it's not to say even that lawyers might not write to us and say, oh, dear Liza, I've just been instructed by Johnny and justifying why this looks as though it should be a 60-40 case. And we get that occasionally. And, that's not right. The courts treat percentages as a checking tool. In the court process, either parties can agree or a judge can decide what ought to be done. And it's very, very common for there to be a discussion afterwards about what the net effect of that is. And if people say, well, that ends up being a 58% split in one person's favour, then the court might say, or we might say, well, actually, that's a crazy departure from 50-50. But as you say, 90-10, 80-20 is way off. So, yeah, addressing needs and working out practical solutions is the way to go.
Yeah, and it's really challenging, isn't it? Because we have this discretionary system in the UK and we're dealing with this notion of fairness. And the reality is that what I would deem fair, what Seb would deem fair, what the judge would deem fair, and what the parties would deem fair may well be 5 completely different results. And they could all fall within an order that the courts could reasonably make based upon the law. And I think this is where it becomes really tricky. And this is one of the reasons, going back to things like mediation, is that there's such a push on parties being able to reach an agreement, because it is risky going to court, because you are putting yourself and your future life and your assets in the hands of a third party whose idea of fairness might be very different to yours. Yeah. So it's one of the reasons that we try as hard as we can for most cases to settle them, because it's much better that you reach an agreement that you have, or you reach a settlement that you have agreed and that you can move forward from, than having one imposed upon you.
It's about control, isn't it? If an agreement doesn't get reached, then ultimately a judge will have control and will tell you what's going to happen, and you lose all control. And judges are human. And as Lisa says, the system is based on discretion and nuance, not on pushing numbers into a machine at one end, turning the handle and getting the answer at the other end.
Yeah. Next question then is, if debt has been accrued during the marriage by one party, some of the debt has been added to a joint mortgage, is the other party still liable? There seems to be a lot of debt here on hidden credit cards. So I suppose perhaps a general kind of overview on how the courts deal with debt in divorce proceedings.
Yeah, and this again is another issue that arises regularly enough. Joint debt and individual debt are the two categories that we analyse them under. And if a family runs its finances and pays for the summer holiday or a summer holiday on a credit card, and that's common and known about, then that clearly is a joint debt. If that credit card debt is cleared by adding to the mortgage, then that's reasonable and that's shared and shouldn't be lumped on one person's lap only. But in situations where one person racks up an enormous amount of debt, well, not necessarily enormous, racks up debt without the knowledge of the other on things that could never be considered joint, gambling debt is an obvious one, then we would be looking at making sure that that gambling debt, whether it's on credit cards or whatever, is apportioned to the person who's incurred that debt. It comes back to a comment you made a little while ago, Lisa. It's about common sense factors. It's common sense. It's what's fair. And clearly people want to avoid debt chipping away at what they have and therefore what they have available to them to rehouse or re-establish their new home. But if it's fair that the debt is shared because it's genuinely something derived from the running of the family, then that's the right outcome.
It's really tricky, isn't it? You've got that litigation risk as well, because there's that case that we quote quite regularly. I can't remember the name of it, but it was where a significant amount of debt was accrued in relation to prostitutes and gambling. So very much along the lines of what you were talking about there, Seb.
That's not joint, is it?
It was a multi-million-pound case again. So again, not quite the sort of everyday case. But in that case, actually, the judge decided that you take your partner as you find them. And because they had been using prostitutes and gambling throughout the marriage, that we then couldn't discount the debt at the end of the marriage. So it is a really, really tricky one. And you also have to be very careful that you're not spending money litigating and spending lots of money on lawyers' fees, arguing purely about debt, because you're basically throwing good money after bad money, ultimately. So there's a very careful balance, cost-benefit balance that needs to be done.
That's exactly right. There's a good question that we've had here that we talked about the other day. Would spousal maintenance stop if I got a job having been a stay-at-home mum? Is there an end date to maintenance?
So there will be an end date within the order. So your order will usually be for a fixed term. Spousal maintenance is all about need. So it comes back to that income need. So nobody has an entitlement legally to share in future income. But what you have is a legal entitlement to have your income needs met. So the starting point is that both parties have the obligation to maximise their income. So whilst there may have been a certain agreement in place during the course of the marriage, whereby one party may have worked part-time or one party may have stayed at home to look after the children, there is an understanding that now we're trying to provide financially for two homes, that both parties need to do everything they can to maximise their income. But often there will still be a mismatch because, for example, if one party has been at home raising the children for 10 years, it's going to take them time to get back into the labour market, and it's unlikely that they will be earning the same salary as their ex-partner who hasn't had a break from the labour market. So there's going to be this difference. So what we're looking at is maximising income. And then after that, what we're looking at is, right, what are your income needs? So the starting point is that both parties would complete a schedule of outgoings. So that's a monthly schedule of all the payments that you have to make for everything. So mortgage, rent, gas, electric, but also sort of a holiday budget. If you had holidays during the course of the marriage, it has to be in line with the relation, the standard of living that you had during your marriage, and food, children's uniforms, all of these types of things. Yeah. Now, if one party isn't able to meet their monthly outgoings from their own income, which they've maximised, and the other party has a surplus after they meet their income, then that's where your maintenance need comes in. Now, the question about going back to work then is, what that's doing, or increasing your hours, what that's doing is it's reducing your income needs, because you're able to meet more of that from your own resources, and therefore arguably the spousal maintenance could be reduced. And spousal maintenance is variable throughout the life of the term. So if you have a spousal maintenance order for 5 years, for example, and your circumstances change so that actually in 2 years' time you don't need that money anymore, your partner or ex-partner would be well within their rights to make an application to court to downward vary or end that maintenance order. So yeah, absolutely, it can make a difference.
And that's right, yes. And again, good communication. A trip to court to end it can be avoided by a discussion and an agreement. But I think that's right. The days of what we used to call joint lives maintenance are long gone. Maintenance is a tool designed to help people reach financial independence from their former spouse. Maintenance is an ongoing connection. It prevents the couple from having a clean break. A clean break is always the court's preference if it can achieve that, and so is our focus as well. But maintenance is a really valuable and really important tool when one person is financially much weaker than the other.
Yeah, I mean, the other thing that we can do is we can capitalise sometimes as well. So it might be that rather than actually to achieve that clean break, rather than having monthly income payments coming in, that an additional lump sum is given to the financially weaker party so that they can either invest that and have the income from that, or it may be that it means that they can purchase property mortgage free. Yeah. So that it reduces their outgoings and keeps it within what's affordable. So there's lots of different things that we can look at and different ways of doing that.
Ties into mediation again, Lisa, doesn't it? If there is a spousal maintenance order in place for 5 years and a couple had an end to their marriage, that means they don't talk to each other at all now. If it's felt that one doesn't need as much as they are getting, then mediation is a really good way to try and address that.
Yeah, absolutely. I think we've had loads of questions that have come in on the chat.
Yes, let's jump into that.
So I think we should I think we've done the bulk of the ones that came in beforehand, but I think it'd be helpful if we probably move along to the ones from the live chat. So first one we've got here is, what are the potential negative results of using the Form E financial figures which are 10 months old in the D81? So the D81 is the form that goes to court alongside the financial order when we're asking the judge to approve the financial order. And it's kind of a summary of what the finances are. So it's not as detailed as the Form E, but it's a summary, and it's what the judge will be considering when deciding whether the financial order is fair.
10-month-old figures aren't accurate. I mean, they might be, but the D81, that statement of information, is a really important document and really significant. One of the most important bits of it comes at the very end with a statement of truth. And people complete the statement of information with a summary of their finances and sign to say all of the details contained in it are accurate and correct. If they're 10 months old, or people think, oh, well, I gave that information almost last year, it'll be fine. Well, it may be fine by chance, but equally it may really not be fine. And the purpose of the statement of information is to arm a district judge with a really clear and accurate picture of a divorcing couple's financial situation, so that the judge can check whether the agreement they've reached in the consent order is fair or not. And judges don't simply rubber stamp them and send them back and there you are, you've got your consent order, whether it's fair or not. They do scrutinise them. And I think it's true to say that, especially in the last 5 years, we found that they are scrutinising them even more carefully than they were doing before. And it's very common that we get an email back from the court or a letter back from the court saying a consent order has been passed to the judge, and the judge would like to understand why this couple is not sharing their pensions and doing what they're doing. And we need to justify it and go back to the judge and explain why a couple has agreed what they have agreed. The judge can't tweak that agreement, but they can refuse to approve it. And in extreme situations, and it happens rarely, but it does happen, a judge can say, well, look, this appears really unfair. This couple is asking me to approve something I don't think is right. I want you both to come to court. And ultimately, a judge will look at people square in the eyes and say, do you realise that what you're agreeing to isn't fair and isn't what would normally happen through this court? And then it's people's own risk. But going back to relying on old figures, if one spouse relies on figures that are almost a year old in their D81, it might completely ignore the fact that they've won the lottery, and that fundamentally changes the landscape and what is available to meet people's needs. Or Someone might have accrued loads of debt derived from the house for some reason, and then one of them, invisible to the court, is in a really disadvantaged position. So bang up to date figures in the D81 are really important. One of the hurdles that we do find with the D81 often, Lisa, don't we, is with pension values. There are lots of public sector pension funds that say, oh yes, we can get you a value for your pension, but it could take 6 months. And people think, oh, well, I'm just going to rely on that one that I've got from 2 years ago. I'm not going to wait 6 months. It could be really dangerous. And so, yeah, up-to-date figures and knowing what's what is the right way forward. Transparency, that ongoing duty of full and frank financial disclosure is vital.
How does inheritance work if my husband spends some of it going through the divorce? This is a really interesting one because I think it depends on what he spends it on. If he goes on some luxury round the world cruises and is living the absolute life of Riley, then obviously that is potentially something that you can raise because he's dissipating assets effectively to try and put them outside of the scope of your claim. However, if his inheritance is going down because he is paying to live somewhere else, even if he has gone to, he is renting somewhere that's perhaps a little bit lavish, or he's doing, his inheritance is reducing because he's paying legal fees effectively throughout the divorce, then that's something that the courts aren't going to discount. So he will be able to look at the current value that he's got in his accounts rather than the value that was there previously. Similarly to if somebody were to put legal fees on a credit card or take out a loan for legal fees, then that's going to appear in their side of the balance sheet for the purposes of the divorce proceedings. So I think more detail would be needed there as to what we think the inheritance has been spent on, and equally what impact that has, because actually it goes back to that inheritance, should it be ring fenced or not argument. So it may well be that the inheritance would have been ring fenced anyway because we can meet needs from the asset, the matrimonial asset, and so the inheritance becomes a bit of a red herring, if you like. So there's quite a lot going on there that sort of more information would be needed.
And again, comes back to the common sense and reasonableness point. Buying 6 Porsches isn't really what's needed, but living.
Although at least if he buys assets, we've still got the assets to value.
True. Yes, true. We've had some really interesting questions in, haven't we?
Yeah. The likelihood of a measure order when the wife was a stay-at-home mum for 4 years, has no hope of a mortgage on a new home for her and her 2 young children aged 2 and 4.
I like the look of this one.
Measure orders are challenging. Measure orders are a bit like joint lives maintenance orders.
Yeah.
Going back sort of 15 years, they were pretty common.
Yeah.
A measure order is where the property, you effectively delay the sale until the children reach maturity. So you decide on how the interest is, whether it remains 50-50 or 60-40.
Yeah.
And then there's trigger events. So the property can't be sold until one of those trigger events hit. And they're usually things like remarriage, youngest child reaching the age of 18, leaving full-time education, etc. I can't say that I've done a measure order recently.
No, I think we've done a couple, but they are very much less common than they ever were. And I know that what I've heard judges saying, I don't want to have a measure order if we can avoid it. There is, and I think this is an important element here, there is no right to own a house if one has been owned during the marriage. And judges do say, well, there isn't enough equity in this house for you both to go off and buy, no matter how imaginative a mortgage broker might be. And it may be that a house has to be sold, the relatively modest equity divided, and people go off and rent. But this question talks about one person having been out of work for 4 years and has no mortgage capacity. Then, of course, a measure order is the kind of legal tool that we might consider as an option to ensure that their needs are met, their housing needs are met, and those of the children. But we've also got to consider the other person, because if they remain tied to the mortgage on the family home, then they're essentially going to be prevented from getting a mortgage elsewhere. If they're going to be contributing towards that mortgage, they may find it impossible to afford rent elsewhere. And so we really do have to look at the whole picture. Yes, a measure order seems like a really tempting, efficient solution to a problem, but in implementing it, it might create 2 other massive problems that make it a bad idea. So as with the other questions, many of them, we need a really careful analysis of what's what there is available what prospects does that stay-at-home mum have of going back to work? What do they do? How much will they earn if and when they do return to work? What will their mortgage capacity be when they go back to work? Do we need to look at a 2-year plan or a 4-year plan? If we're looking at a 16-year plan, then I think mesh order is essentially an impossibility. But if it's a 2-year plan, then maybe that's a good idea. And I very often encounter, and it's usually fathers who like the idea of a mesh order because they want to make sure that their children are comfortable and can remain in their home and are prepared to allow for a bit of time to pass before the house is sold, and it can work nicely. But I don't remember the last time a judge imposed a mesh order.
Yeah, they are challenging. It's that change in society that's really happened in the sort of last 15 years means that we tend to go through peaks and troughs of like popularity for various different types of orders. And yeah, mesh orders are just one that really have fallen out of popularity with the judiciary, who are much keener to get that clean break, to make sure that that line is drawn in the sand and that both parties are able to sort of move on without any link to the link remaining in place.
Yeah.
That definitely seems to be the priority, certainly at the moment.
And I think it's very hard for people often to imagine what life might be like after their divorce and the financial negotiations conclude. Some obviously have a really clear idea, but people can form new relationships quite swiftly, or want to remarry, or find different jobs, or retrain. Life goes on, and to have those ongoing connections can be really restrictive. To have a clean break, to free people up to get on with their own lives independently, and to co-parent without that sense of financial resentment from ongoing maintenance or whatever it might be, is a real ideal if it's possible.
Yeah. There's an interesting one here about the other party not engaging in court proceedings, and having a 5th directions hearing in November, contempt of court being issued twice, but that never happened. What can they do? I mean, my experience of this is that if you get to the point, firstly, either you apply for them to be committed for contempt of court, and that can sometimes be enough to provoke the other party when they realise that actually they could be sent to prison for this. So that's one course of action that can be taken. The other, which has probably happened more often in the cases where I've dealt with a particularly difficult other party who's not engaging, is that the courts can basically say we will move forward to the final hearing, and we will deal with the final hearing based on the evidence and the information that we have, and we can draw inferences from the other party if they haven't provided. So, for example, wife has said that the husband's got £150,000 pension that he hasn't disclosed, and husband hasn't provided any documentation, then arguably the judge could say, well, I believe that or let's say husband was saying it was worth 50,000, then judge could say, well, I believe that if that pension was genuinely worth 50,000, you would have provided the documentation. And the fact that you haven't means that I'm going to assume that it's worth 150 for the final hearing, and I'll just proceed. They can also move forward to final hearing on the basis that if the other party doesn't attend, final orders will be made in their absence.
Yeah, I've seen that often enough.
So there are things that can do. It's really tough because courts don't want to have to make those they want to go through the right avenues and make sure that they're making the right orders. And the worry with dealing with it in either of those ways is that the wrong order is being made because we don't have all of the information, but they can deal with it that way if needed.
And judges are human beings, but they're also invariably really experienced lawyers, family lawyers, who get a real sense for what's going on. And sometimes people don't engage in the process and are really difficult and evasive and unhelpful and refuse to comply with orders. Judges know what they're doing. They can tell, but they need to tread carefully too. But that's right. The courts can proceed to a final hearing and give the other person an opportunity and say, well, unless you provide this information by X date, we're going to go ahead without it. And we're going to make decisions that you may well be really unhappy with.
Yeah.
Even that's not ideal because, there are unknowns, and any decision based on an unknown is risky. But yeah, I think you're exactly right. I think in direct answer to that question, committal to prison is a serious tool that could be used there, especially.
Yeah, you need to get past the threat and issue that application.
Yeah, do.
Because that usually gets them on board once they suddenly realise they're before a judge and they could be sent to prison for this.
And if the police are knocking, and they will get involved.
Yeah. There's an interesting one that came in relation to what we were talking about on disabilities, just saying, what if the children had sort of what if there were long-term, so they talk about autism and medical issues in relation to housing needs with young adults. So we're talking about children that are older. If you have a young adult, so somebody who's 18, 19, for example, who cannot live independently because of their medical condition, then that's absolutely something the court can take into account in relation to housing needs. What we would need is evidence of that, though. It wouldn't be enough for us just to say that they can't live independently because of their condition. We would need doctor's reports or an occupational health assessment or something that would actually provide us with the evidence that that was the case, because the judge would need that. But yeah, absolutely.
We need to understand fully what assistance, financial and otherwise, the state would provide that individual to understand where there is a shortfall or where there is a need that isn't being provided for elsewhere.
Yeah.
Again, more information.
I reckon we can get another couple of really quick ones in. Yeah. So we've got one here. My husband's moved out. He's not paying the mortgage. What can I do?
The mortgage company don't care who pays it. You're jointly and severally liable for it, they would say. So they want it paid. And if you only pay your half and leave the other half unpaid, it counts as a default, 3 defaults, and they can start to repossess. So be very careful. But if he was paying or contributing and has moved out and has stopped, you can consider interim spousal maintenance, a court order where a judge assesses the outgoings and income and can tell the husband to pay his half or all of the mortgage, pending a later decision on all the other finances. One for you, Liza. Do you have to provide financial disclosure if you own property but haven't been married?
So it will depend on how you own property, whether you own it jointly or whether you own it solely. And it also depends on what claims we're talking about here, because the reality is that there is no such thing as common law spouses. So the legal remedies that are available for financial settlements in relation to non-married parties are much more restrictive than in relation to married parties. So if we're looking, for example, at a jointly owned property, the court's only going to be interested in that property. So you're not going to be asked to provide the full disclosure that you would in divorce proceedings. You're not going to have to give details of your income, your capital, your savings, all of that, pensions, etc. The court will just be interested in the property and what's happening to the property. They also won't take into account fairness. They won't take into account needs. They're just looking with cohabitation disputes. They're just looking about who is the legal owner. How is, what is the percent? We are talking about percentages in cohabitation disputes. What is the percentage ownership of the property? And then can one party buy out the other? If not, property is going to be sold and divided in those shares. So much, much more restrictive in the amount of information that needs to be provided.
We've had a little addendum to that question about it seems that in that situation, mediation is underway, and the mediator is pushing for more financial disclosure. As Liza says, there's a stark contrast between married couples and what's assessed, and unmarried couples who jointly own a house and what's considered there. With the unmarried joint house owners, they're joint house owners. That's what the law looks at. Yeah,
I think you definitely need more information. The only reason that I can think of for you having to provide more disclosure in relation to a cohabitation dispute is if the claim that's being made is in relation to children.
Yes.
So if one party is trying to make what we call a Schedule 1 claim, so that's a claim to meet some capital needs or income needs in relation to the children, and these are usually done in big money cases again, then in those circumstances you do have to provide more information. But again, the claim is just limited to the needs of the child. It's not in relation to the needs of the ex-partner. You said spouse then? Ex-partner. Okay, well, it has...
What's an hour?
That hour has flown by. Well done. You've popped your live cherry there, Seb.
There we are, done. I've not sworn yet.
Thank you to everybody for joining us today. There's been lots of really great questions. I'm sure another one of these will be popped in our diary soon. Yeah. Thank you, everybody, for taking part today, and thank you for all your great questions.
Yeah, thanks, everybody. Goodbye.